Good morning, Honourable Chairperson. Good morning, Honourable members of the committee, my colleagues from the National Prosecuting Authority, members of the media, ladies and gentlemen, the viewers at home, the listeners on radio. Chairperson, I would like to thank the Portfolio Committee for inviting the National Prosecuting Authority to specifically brief the committee on the withdrawal of the charges against Minister of Finance, Pravin Gordhan. Allow me the opportunity to first introduce my team. On my right is Dr. Silas Ramahiti, SC, who is a Deputy National Director of Public Prosecutions. Directly behind me is Advocate Toko Majukweni, who is an Acting Deputy National Director of Public Prosecutions, and she heads the National Prosecuting Services. Behind Dr. Ramahiti is my spokesperson, Advocate Luvuyo Mfaku. Chairperson, would that suffice? Thank you. Chairperson, we are honored to appear before this committee. Well, we were honored to appear here a few weeks ago on the 12th of October 2016 when we presented the NPA's annual report in terms of the provisions of Section 35, subsection 2A, read with Section 22, subsection 4G of the National Prosecuting Authority Act. We accept that today's invitation is in terms of the provision of Section 35, subsection 1 of the NPA Act, which provides that the prosecuting authority shall be accountable to Parliament in respect of its powers, its functions and duties under the NPA Act, including decisions regarding the institution of prosecutions. When we previously appeared before this committee, we briefed the committee on the decision of the Acting Special Director of Public Prosecutions and the head of the Priority Crimes Litigation Unit, taken in consultation with the Director of Public Prosecutions of North Gauteng to prosecute Mr. Opa Magashula, Mr. Ivan Pillay, and Minister Pravin Gordhan on inter alia fraud-related charges. Chairperson, I'd like to briefly just deal with the initial charges or the decision in respect of to prosecute the persons in question. I was briefed by the Acting Special Director together with the Director of Public Prosecutions of North Gauteng in respect of the decision to prosecute, which decision was taken in consultation in terms of Section 24, subsection 3 of the NPA Act. I was satisfied on the merits that a case had been made out on paper as per the briefing. I was further briefed on public interest considerations as a direct result of the profile of the individuals concerned, along with the fragile state of our economy, and that such a decision would appear on the face of it political as a direct result of the political climate we currently find ourselves in and had been in a few weeks ago. In this regard, Section 22, subsection 4F, requires the National Director to bring the United Nations guidelines on the role of prosecutors to the attention of the Directors of Public Prosecutions, Special Directors and Prosecutors, and to promote their respect for and compliance with the principles contained therein within the framework of our own national and domestic legislation. Chairperson, these guidelines make reference to the Universal Declaration of Human Rights, which enshrines the principles of equality before the law, the presumption of innocence, and the right to a fair and public hearing by an independent and impartial tribunal. This is further enshrined in Section 9, subsection 1 of our Constitution, which provides that everyone is equal before the law and has the right to equal protection and equal benefit of the law. The UN guidelines on the role of prosecutors require prosecutors to carry out their functions impartially and avoid all political, social, religious, racial, cultural, or any other kind of discrimination. The impact of this decision, not just on the parties concerned, but also the broader public interest in the matter, was certainly given serious consideration. The officials concerned advised that this was by no means an easy decision to be made, and due regard had to be given to the effect of the decision. As with all matters where public interest considerations are applicable, a careful balancing of all considerations were made. I am mindful, as are all prosecutors in the country, that consideration of public interest and public sentiment around our decisions must be carefully considered, but similarly that these factors cannot dictate whether we prosecute or not. We must abide by the rule of law and ensure that our decisions are sound and legally sustainable. Chairperson, we are in fact enjoined by the international standards that we as a prosecuting authority and country subscribe to, such as in the Convention Against Foreign Bribery, to ensure that our independence is reinforced in the considerations of economic and political considerations, as well as the stature of either private or legal entities, do not influence the decisions we make. Being mindful of all this and the institution's constitutional imperatives and the duty to act without fear, without favor, or without prejudice, I was satisfied with the briefing that there was a prima facie case based on the evidence in the matter, and that to decide not to proceed because of the impact of the decision would erode the rule of law and the institution's duty to act without fear, without favor or prejudice. Chairperson, in terms of Section 179, subsection 6 of the Constitution, the Minister of Justice and Correctional Services must exercise final responsibility over the National Prosecuting Authority. This is further confirmed by Section 33, subsection 1 of the NPA Act, which obligates the Minister of Justice and Correctional Services to exercise such final responsibility over this all-important institution. In recognition thereof, and in compliance with the provisions of Section 33, subsection 2 of the NPA Act, I subsequently briefed the Minister of Justice and Correctional Services of the decision taken by the Special Director in consultation with the Director of Public Prosecutions on or about 4 October 2016. I did not seek the Minister's permission for the prosecutors to proceed with the matter. At the conclusion of the briefing, I requested the Minister to brief the President. I had done so because this matter had a large public interest. I further did so because this matter related to a sitting cabinet minister. I have done this in previous occasions. A typical example is when the ambassador or the former ambassador or high commissioner to Australia, Mr. Spoo Ndebele, was facing charges of inter alia corruption. Similarly, in that matter, and it's not unusual to do so, I briefed the Minister of Justice and requested the Minister to brief the President. So this certainly was not an unusual situation. Chairperson, I believe the Minister briefed the President during the latter part of that week or the weekend. Allegations have been leveled that I discussed this matter with the President at a meeting held during the afternoon on Monday, 10 October 2016 at Luthuli House. Chairperson, that is completely incorrect. The Minister had briefed the President long before this meeting. During the afternoon of 10 October 2016, I received a call from the Minister of Justice and Correctional Services, who invited me to attend an urgent meeting around the violence that had erupted as a direct result of the Fees Must Fall campaign at institutions of higher learning. I recall buses were burning, streets were barricaded, shops were being looted, buildings and vehicles were being vandalized, people were being assaulted. It was almost a complete state of anarchy. According to the Minister, the President had called for an urgent meeting with the ministers of the security cluster. My understanding was that the President was leaving the country later that day during the early evening, and the meeting could not be rescheduled. The President did not invite me to this meeting. The President was not even aware that I would be in attendance at this meeting until I arrived at the meeting. The Minister of State Security was deputizing as the Minister of Police. He was present in this meeting. The Minister of Social Development was deputizing for the Minister of Defense and Military Veterans. She was present in this meeting. The Minister of Justice was present in this meeting, and he was of the view that I could contribute much more than he could at this meeting and requested my attendance. Chairperson, I can still recall having to first cancel a dentist appointment that very afternoon at extremely short notice before confirming my availability to attend this meeting. The issue of the charges against Minister Pravin Gordhan was not discussed at this meeting at all. The only issue that was discussed was the issue around the violence that had erupted at the institutions of higher learning as a direct result of the Fees Must Fall campaign. Chairperson, I would verily like to believe that my attendance at the meeting did not compromise my independence nor my integrity. Instead, my attendance at the meeting should be viewed in the prevailing circumstances of the day and that it was necessary. The National Director should be able to meet with anyone regarding any issues associated with his responsibilities or related to state security and still be able to act independently, objectively, and impartially, and without fear, without favor, and without prejudice. Chairperson, I'd like to briefly speak about the media briefing of 11 October 2016, when I announced the decision that Minister Gordhan would be prosecuted. The speculation around the investigation into the rogue unit, the arrest and prosecution of Minister Gordhan had been well publicized since 2015, occasionally escalating in momentum, especially the alleged political motives for such an investigation, arrest, and prosecution. We called a media briefing to take the country into our confidence, to dispel any notion of political and/or any other perceived interference. As head of the institution, Chairperson, I deemed it appropriate for me to announce that decision. Chairperson, it is now common cause that I review the decision in terms of Section 179, subsection 5D of the Constitution, which decision I announced on 31 October 2016. I want to return to 11 October 2016. On that day, when I announced the decision of the Acting Special Director of Public Prosecutions and the head of the Priority Crimes Litigation Unit, made in consultation with the Director of Public Prosecutions North Gauteng, that Mr. Pillay, Mr. Magashula, and Minister Gordhan must be prosecuted and arraigned on various charges, I alluded to the provisions of Section 179, subsection 5D of the Constitution, which empowers me as the National Director to review a decision to prosecute or not to prosecute, after having consulted the relevant director and after having taken representations within a period as specified by me from the accused persons, the complainant, and any other person or party whom I consider relevant. When I made the announcement, I did extend an invitation to Mr. Magashula, Mr. Pillay, and Minister Gordhan to make representations to me as the National Director. This is clearly in line with the provisions of Section 179, subsection 5D of the Constitution, read with Section 22, subsection 2C of the National Prosecuting Authority Act, to review a decision to prosecute and to decide whether to continue or discontinue a prosecution. Chairperson, the receipt of representations and requests to review decisions is very much a daily occurrence. The NPA receives representations from accused persons and/or their legal representatives in respect of matters, both in the lower courts and in the high courts, which are submitted either directly to prosecutors, control prosecutors, senior public prosecutors, chief prosecutors, the officers of the directors of public prosecutions, the officers of special directors of public prosecution. This serves as checks and balances in a criminal justice system, and so too does my constitutionally enshrined powers to review. Chairperson, since my appointment in June 2015, I have reviewed numerous cases. I have overruled the original decisions of directors of public prosecutions and/or special directors to prosecute or to discontinue prosecutions in approximately 16 matters. I have also agreed with the original decisions of directors of public prosecutions and/or special directors in approximately 94 matters. Typical examples of such cases include members of parliament, such as Tony Ngeni's driving under the influence charges, in which I agreed that the prosecution must continue after being requested to review the matter. Similarly, in the matter of Faiz Jacobs here in the Western Cape, I also agreed with the original decision of the Director of Public Prosecutions that the prosecution must continue. However, in the matter of Pandey and Madu down in KwaZulu-Natal, I disagreed with the decision of the Director of Public Prosecution, and I have subsequently directed that Mr. Pandey and Colonel Madu be prosecuted. I verily believe that there's a general public misconception as to what my role really is as the National Director, and there's no full appreciation of the structure of the National Prosecuting Authority. Whilst I have the power to institute a prosecution, I would only do so in very rare instances. This matter was certainly not one of those very rare instances. Thus, Chairperson, if I made a decision to prosecute, I would not be competent to review my own decision in terms of both the Constitution or the NPA Act. I am vested with and retain the power to review a decision to prosecute after complying with the provisions of the Constitution and the NPA Act, as I've already alluded to. Hence my invitation to make representations if the accused in that matter, as they were at the time, had wished to do so. Chairperson, Section 179, subsection 5C of the Constitution, as replicated in Section 22, subsection 2B of the National Prosecuting Authority Act, empowers the National Director to only intervene in the prosecution process when policy directives are not complied with. In respect of this particular matter, there were no policy directives that, or the policy directives were complied with. It was not a situation of policy directives not having been complied with, or at the very least, that none was brought to my attention. I have always been mindful, and I remain mindful, of the constitutionally entrenched rights that everyone is equal before the law, and everyone has the right to equal protection and equal benefit of the law. Chairperson, on Friday, 14 October 2016, Freedom Under Law and the Helen Suzman Foundation, through their lawyers, submitted a communication to me in which they requested me to withdraw the charges against Minister Gordhan unconditionally on or before a specified date, failing which they would exercise their right to seek urgent recourse to review and set aside the decision to prosecute Minister Gordhan. The following Monday, 17 October, and the Tuesday, 18 October, both Mr. Magashula and Mr. Pillay requested me to review the decision to prosecute them by way of representations to me in terms of the provisions of Section 179, subsection 5D of the Constitution, through their legal representatives. I can assure the public, and I can assure this committee, Chairperson, that Mr. Pillay and Mr. Magashule were accorded a very fair and a very dignified hearing whilst making their representations. They did so both verbally and in writing. This much has been confirmed by their respective legal teams that represented them during the submission of the representations. I obtained the views of the prosecuting team and the acting special director prior to reviewing the matter. I also extended an invitation to the Commissioner of SARS, being the complainant in the matter, and to the head of the Hawks as the investigating authority to submit representations to me. Both parties elected not to make any further submissions. As a result of the representations and submissions received, I directed further investigations into the matter. The outcome of these investigations ultimately informed my decision. The Hawks, however, did write to me at the 11th hour during the late afternoon of 30 October 2016 to request me not to withdraw the charges. The head of the Hawks had learned through the media that I may overrule the decision to prosecute. The further correspondence from the Hawks did in any event not take the matter any further. Nevertheless, Chairperson, the horse had bolted at the time, as I had made my final decision earlier that afternoon prior to receiving the further communication from the Hawks. The horse. Chairperson, after due consideration of the matter, I decided to overrule the decision to prosecute Mr. Magashule, Mr. Pillay, and Minister Pravin Gordhan on the charges listed in the summonses and directed that the summonses be withdrawn with immediate effect. As a result of this, there was thus no longer any need for the aforementioned persons to appear in court in respect of the charges that had previously been preferred against them. Again, after reviewing the matter and before announcing it, I briefed the Minister of Justice and Correctional Services in giving effect to the provisions of Section 33 of the NPA Act and Section 179, subsection 6 of the Constitution. I once again further requested the Minister to inform the President of my review decision. I once again did so on the same grounds as previously stated. Chairperson, on 1 November 2016, I received a letter from the Chairperson of the General Council of the Bar, Ngalwana SC, to which he attached a letter of complaint against me from the Secretary General of the Economic Freedom Fighters, the EFF, which letter requests the GCB to disbar me. The EFF raised 5 allegations against me in their letter to the GCB. They firstly allege an improper meeting at the headquarters of the ruling political party in reference to the meeting at Luthuli House on 10 October 2016. Secondly, they allege the use of an act which is inconsistent with the Constitution. This is with specific reference to the charges preferred against their leader for allegedly contravening the Rioters Assemblies Act 17 of 1956. Thirdly, Chairperson, they allege interference with the administrative powers vested in accounting officers and executive authorities. And this is with specific reference to the charges preferred against Minister Gordhan. Fourthly, the EFF allege an improper meeting with an accused person, and this is in reference to the meeting at the Luthuli House with President Zuma and ministers of the security cluster on 10 October 2016. Lastly, Chairperson, the EFF alleged discussions with ministers in matters where the NPA will probably have to make a decision as being inappropriate, again in reference to the meeting at the Luthuli House in respect to the violence associated with the Fees Must Fall campaign. The EFF concluded their letter by informing the GCB that it reserves its right to pursue the matter through the courts should the GCP not act against me. Chairperson, I am aware of a further complaint. It's a complaint It's a well-publicized complaint by Mr. Matthews Poza, a lawyer, a politician, and the former Treasurer General of the African National Congress. Mr. Poza has purportedly laid a complaint against me at the GCB. I am, however, yet to hear from the GCB in respect of this particular complaint. I have learned of this complaint through the media. Chairperson, on the very same day of 1 November 2016, Freedom Under Law and the Helen Suzman Foundation, once again through their lawyers, wrote President Zuma requesting the President to provisionally suspend Dr. Pretorius SC, Advocate Mzanyati, and I by 7 November 2016. This is this coming Monday. Pending inquiries into our fitness to hold office in terms of Section 12, subsection 6A of the National Prosecuting Authority Act, failure which they endeavor to exercise their rights on an urgent basis. Freedom Under Law and the Helen Suzman Foundation have further invited Dr. Pretorius and I to resign from our positions without any further delay. They direct no such request in respect of Advocate Mzanyati. Chairperson, the above matters and potential pending litigation somewhat limits our ability to engage more fully with the committee on these matters. We once again thank you for the opportunity for inviting us to present on this matter today. We will continue to exercise our functions without fear, favor, or prejudice, irrespective of the station in life of any person and or entity. We will continue to consider the interests of the community, but will not give heed to the wishes of the community. We will continue to uphold the independence and impartiality of the prosecuting authority and prosecutors generally, which is legally and constitutionally entrenched. In this regard, the NPA Act inter alia provides that a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law.